seek some mental health because
I'm
something's
sorry.
wrong with you. You have
You
a
said
mental
what?
problem. You have a mental problem.
I
If
have
you
a
think
mental
the laws
problem.
in the
How?
United States don't apply to you and you get to make them up as you go along, like you know more than everybody else in the world, there's clearly something wrong with you.
No, what did I make?
Welcome back to another courtroom roller coaster, ladies and gentlemen, and trust me, today's case is not just a ride, it is a full-blown theme park. We've got legal jargon flying across the room like dodgeballs, a tenant convinced she's found a loophole big enough to drive a moving truck through, and a judge who has absolutely had it with the sovereign citizen rulebook that doesn't actually exist right from the start. You'll notice the tension in the air, the kind that shows up before someone makes a bold statement like, "I read the law," and then proceeds to misquote the statute. The plaintiff is waiting to get to the point. The judge is trying to keep the courtroom from turning into an open mic debate session. And Miss Battle? She's ready to argue anything, including concepts that haven't been legal since medieval times. Literally, over the course of this hearing, we're going to see objections fly, misunderstandings escalate, and patience tested to its absolute limit. Watch closely for the judge's expressions, the raised eyebrows, the long pauses, the deep sighs that only judges, teachers, and tired parents can produce. It's gold. And the moment Miss Battle drops lines like, "I stated it under common law," buckle up, because Judge Washington is not letting that slide. And before we dive in, let me warn you, the drama builds slowly, then blows up completely when HUD policies, administrative hearings, and federal statutes enter the chat. The judge tries to keep it grounded. The attorney tries to keep it coherent. And Miss Battle? She's conducting her own legal orchestra in another unit.
I find everyone's very funny but my own. I'm French.
Mr. Fantera, if you, the court will call the case of the Ranches of Rosebrook versus Anise Battle, case number 25C-1245.
Good morning, Your Honor. David Fantera on behalf of the plaintiff.
Battle, please unmute and state your name.
Anise Battle, appearing especially, not generally.
Thank you. All right, we're here for the continuation of the hearing today. Battle, when you're not speaking, please.
You said, can I mute my mic when I'm not speaking?
Correct. Thank you. All right, Mr. Fantera, I believe that we are in the middle of your, well, actually it was Ms. Battle's direct.
Yeah, I think Miss Battle was cross-examining Miss Charles.
That's correct. Ms. Battle, are you ready to proceed?
Yes. So, Don, do you have a signed lease between me and you in this case?
Yes.
Did I ever waive my rights or agree to the terms in writing?
What's the question?
Did I ever waive any of my rights or agree to your terms in writing?
Your Honor, I object. I have no idea what that means.
Meaning that there are waivers inside of the lease.
Your Honor, she's got a signed lease. That lease was, we moved to have that admitted last time, and it was admitted. Miss Battle did not object. So I don't know what she's asking right now when she talks about a waiver. She signed the lease.
Okay, that's fine. Are you aware of the notice of rescission that was sent?
Yes.
I object. Rescission, we can't go down this road again.
Why are we not going down the road?
Let him finish his objection, please.
Okay.
Your Honor, this case is not about rescission. It's about, this is a non-payment of rent, pay and stay case. The question is, how much money does she owe in order to stay in her lease? She believes, and she stated, and she was overruled by Judge Vandenberg, and I believe by you, that her belief that she rescinded her lease and therefore she gets to stay until she finds a new place is not the law, and she should not be allowed to pursue that line of questioning. This is not about rescission, which, by the way, she hasn't done anyway.
All right. So your argument is that her question is not a legal question and therefore you object.
It's not based upon law.
It is based upon, what law is it not based upon? It's based upon common law. You have not proven or stated any laws or facts that back what you're saying. Unlike me, I have.
Yeah, but you stated them all wrong. And one of the things you stated was the Magna Carta, which was from the 12th century in England.
No, I stated it under common law
Everyone, please
and
stop.
landlord-tenant acts.
That's not, we're not under common law anymore, ma'am, and that's a part of the problem with sovereign citizens. They think they know the law when they don't. That is
Well,
not.
that sounds prejudiced and biased because I'm not a sovereign citizen. So it seems like you're
Attention to the energy shift. Judge Washington steps into the session calm, composed, and ready, but you can already sense she's walking into a storm. Miss Battle, meanwhile, comes in fully loaded with courtroom vocabulary she picked up from Google, TikTok, or maybe a medieval scroll, we're not sure, and there's something subtle happening here. Miss Battle insists on appearing especially, not generally, a phrasing sovereign citizens often use as if it unlocks special legal privileges. Spoiler, it doesn't. The judge keeps it professional, but her tone says, we're not doing that today already. The courtroom is split, one side ready to proceed with actual legal procedure, the other side rewriting the rules mid-sentence. And we're barely 1 minute in. That's the type of chaos that promises a legendary hearing. Here's the thing, Miss Battle believes terminology is her strongest weapon. She thinks if she can reframe the situation with specific phrasing, she can shift the case. But the judge? She's been here before. She has seen every version of pseudo-legal freestyle imaginable. And she's not about to let this hearing derail into a TED Talk on a
tenant act.
Overruled.
My objection is overruled, Your Honor?
No, the objection is sustained. Her question that cannot be asked.
So you're saying I can't ask about the contract that's in question?
No, I'm saying that you have no basis for asking whether the contract was rescinded or not.
Why would I not have basis for asking if the contract was rescinded?
That's not the law. You don't get to unilaterally rescind anything, ma'am.
Well, again, as I stated.
My ruling, I'm not arguing with you anymore about it.
Right. It's not an argument. So just let the record show that there is no law or basis to what she's saying. And she has not yet stated any law or fact behind this objection to asking these questions. I will continue. I will continue. Okay. Did you write me a notice to quit filing this action?
A notice to quit?
Yes.
No.
I think she's referring to a demand for possession,
A demand for possession, yes.
No, a notice to quit.
No.
Right. Do you have proof of delivery or service of any notice to quit?
No, I didn't send one.
Right. Are you aware that MCL 657-16 requires a notice to quit before initiating an eviction?
Your Honor, I object. Miss Battle is confusing the term notice to quit with demand for possession. A notice to quit is how you start a termination of tenancy case. This case was started with a demand for possession. If Miss Battle wants to use the wrong term, she's going to get the wrong answer. The statute says that we can start a non-payment of rent case with a demand for possession, and that was issued. And if she asked that question, Ms. Charles can answer that question.
Is there proof of service? Is there a proof of delivery on that demand for possession?
Miss Battle, can you do me a favor, please, ma'am?
Yeah.
Give me one moment. You studied a statute that I actually need to look up. MCL what?
I'm sorry?
What was the statute that you cited?
MCL 657.6. I mean, not 57.6, 600.
The moment the legal disconnect becomes painfully clear. Miss Battle keeps trying to argue rescission, meaning she believes she unsigned her lease by declaring it so, possibly out loud, possibly to herself. Meanwhile, the attorney calmly explains the reality. She signed the lease, the court accepted it, and the law does not work like a subscription you cancel by shouting "I rescind." Judge Washington's reaction says everything. We're not under common law anymore, ma'am. That line deserves to be on a t-shirt. Miss Battle's insistence on referencing centuries-old concepts like the Magna Carta, which might as well be ancient runes in this context, shows she thinks legal history current law. And it's clear the judge finds that both incorrect and exhausting, but here's where it gets interesting. Miss Battle genuinely believes she has built a solid legal argument. She thinks she's catching contradictions, exposing loopholes, and outsmarting the system. Unfortunately, she's confusing legal definitions, misquoting statutes, and mixing unrelated
Shall be in writing, addressed to the person in possession, and shall give the address or other brief description of the premises. It's a demand for possession, not a notice to quit.
Okay, so is there a proof of service of it on the record?
That's a different question, though. So, okay, go ahead.
But that was the question I asked next. Once he said that the
But I
demand for
wanted to
possession,
clarify your question before.
I appreciate it.
All right, Ms. Charles, please add, her question next is there proof?
Do you have a proof of delivery or service for that demand for possession?
Nope.
Nope. Did you know that under MCL that you're required to have a certificate of service or proof of service on the record?
Your Honor, I object. She's now, again, she's not using the statute changed 10 years ago so that you now need on a demand for possession a certificate of service. And that's what's at the bottom of the page. If she's looking for a proof of service, meaning somebody going to the door, she's going to get the wrong answer again. The term is certificate of service, and I believe Ms. Charles will answer that question differently because there is a certificate of service at the bottom of the demand. So I would appreciate if she's going to cite statutes, she cites them correctly.
Okay, that's fine.
Here we witness one of the most common courtroom misunderstandings, using the wrong term, then building an argument on the incorrect term, then becoming frustrated when no one else validates it. Miss Battle keeps asking about the notice to quit, but this isn't a termination of tenancy case, it's a non-payment case. The attorney calmly tries to explain, but the disconnect grows wider and wider. The judge, trying to maintain order, finally reads the statute aloud. This is the judicial equivalent of, let me read it so we're all on the same page. And the moment the judge clarifies it's a demand for possession, not a notice to quit, you can almost hear the courtroom take a breath, except Miss Battle can't let it go. Instead of adjusting, she pivots. But is there proof of service? Now at least that's a relevant question, and the judge acknowledges it, but there's still friction. Because every answer Miss Battle receives leads her to another path, another half-interpreted legal point, another attempt to force
So let's not make my ruling.
let's just okay. All I'm trying to do is ask questions to make sure certain things are on the record. A certificate of service
Okay,
is not on the disposition. And just like she read on 657-16, was the property described on that disposition?
Yes.
Was there a description of the property?
Yes.
If there was a description of the property?
Correct.
On my copy, there is no description of the property. But let's continue. Does your company participate in HUD programs or accept federal HUD assistance?
Yes.
Okay. Did you provide me with grievance procedures required by HUD?
Did I provide you with what?
Grievance procedures required by HUD.
Your Honor, I object. That's irrelevant. There are no
It's
such grievance procedures under this anything that I'm aware of. I mean, I don't even know what she has a grievance about.
right. The grievance would be with the breach, and you all have a grievance, and hence on why you initiated a hearing for the breach of the contract. So it goes back to HUD because you're publicly funded, right?
No, we're not.
No, we're not publicly.
Well, you accept HUD housing. You accept HUD housing, and you apply, and you are in compliance with HUD laws and policies, correct?
Yes.
Right. Okay. So if you have HUD terms and you're
Your Honor, I object. Miss Battle is taking.
object to it, I didn't say anything yet.
Well, I'm objecting because she asked Miss Charles a question, which was, do you get any funding from HUD? Yeah, most companies do. We do. And then she takes that and starts taking that to a next question. where it says, well, when you get funding from HUD, and then she's assuming.
I didn't assume anything. I asked the question.
Okay, what was the question you were going to ask?
I said, do you have to follow HUD's policies? That was my next
And
question.
she said yes.
Right. And then you objected after that.
No, and then you started the next question.
No, I started the question, but I didn't get it out my mouth before you
Please
objected
just
me.
let her ask the next question, and if you have an objection, I can hear it after she finishes her question.
Okay.
Okay. Are you aware that before you initiate a hearing in court or the administrative process before court, you have to have an administrative hearing by a HUD administrative judge?
Your Honor, I object. I'm not aware of any.
Say no. I mean, that's
Just
not.
say no because you're not aware, and that's okay to not be aware. That just means that you are not aware of the laws that govern.
No, it doesn't, because
This-
it's not, that is not the law, ma'am.
How is it? Okay.
You're making.
Are you aware of the requirement under 42 USC 1437 DK for federally funding or accepted landlords to resolve disputes through HUD before an eviction proceeding?
Your Honor, again, I'm going to object. The fact that Ms. Charles answered the question about having a relationship with HUD doesn't mean we are a federally funded property.
I didn't say that you were federally funded. So let's be clear.
Just read-
I said either federally funded or get federal funds.
This moment right here is a beautiful combination of confidence and confusion. Miss Battle shifts into HUD mode, attempting to build a brand new argument out of thin air that the landlord must follow HUD grievance procedures. Even though she herself is not a HUD tenant, the attorney tries to intervene, but she barrels through with conviction. It's not malicious, she simply believes the presence of HUD-accepted tenants means HUD rules apply universally. It's like insisting that because a store accepts coupons, everyone must use coupons. That's not how it works. The best part? She interrupts the objection to argue about the objection. The judge is trying to let her ask the full question. The attorney wants clarity. Miss Battle wants acknowledgement of her legal brilliance. And yet, the whole time, she's building a skyscraper on a foundation made of marshmallows. Watch the judge's tone here. She's trying to stay fair, patient, calm, but you can practically hear her thoughts. We cannot keep going down this road. We've already taken
Vouchers. You get what I'm saying? You receive funding from HUD.
We are. Do you?
I'm not saying that you're funded and that they give you loans of that nature. I am saying that you are within their practice and policies of HUD guidelines because you accept HUD in Section 8.
Your Honor, I object to this whole line of questioning. Miss Battle does not receive a voucher, and so all of this questioning.
Well, it doesn't matter if I receive a voucher. It matters that you are of that type of entity that needs to go through HUD because you accept those things. So
Your
you
Honor,
agree with those terms and policies of HUD.
Your Honor, she's making that up again.
I'm not making that up. If you're saying that how am I making it up? It's under 42 USC 1437 DK.
Battle.
It's a federal registrar on it.
Ms. Battle, you've made your record. My ruling is still that every entity that has to file a landlord-tenant action does not have to go through that process to collect rent, ma'am. That is not how it works.
Okay. Okay. You're saying that it doesn't have to, but HUD says that
not a
these are
debate.
the
None.
requirements, hence why MCL at the bottom is trying to align with HUD guidelines on the same registrar that I'm talking about. You have those codes at the bottom that match up with HUD.
Move on.
Okay. So, well, obviously, if I can't really get a line of questioning, I'm being objected because he feels it's not right. He is objecting with no laws or facts.
peak courtroom chaos, federal codes, housing policies, administrative judges all being thrown into the mix without context or applicability. Miss Battle references 42 USC 1437 DK with deep confidence, but when pressed, she can't connect how it applies to her specific case. Meanwhile, the attorney tries politely, very politely, to say, none of that matters. She doesn't receive HUD. Which is the key. Without a HUD voucher, HUD administrative procedures do not apply. But Miss Battle treats legal codes like ingredients in a recipe, assuming if it's in the kitchen, it belongs in the dish. Her argument unravels even further when she accuses the attorney of not knowing the law. Yet every time she cites something, it either doesn't apply or she misquotes it. It's like watching someone arguing passionately about the rules of chess, while playing checkers. To the viewer, watch the judge's patience here. She gives Miss Battle room to speak, room to try, room to present something coherent, but every objection, every explanation, every clarification is dismissed by Miss Battle as bias or prejudice. This is when attorneys earn their paycheck, not for arguing law, but for surviving.
Your Honor, I object. The court's already said they have jurisdiction over the
The
property.
court said that she had jurisdiction because she said so, and that's non-judicial.
Okay, Ms. Battle, move on.
Move on to what? If
Not
I
a-
cannot have, this is not a fair hearing, and
No,
again, this is why
you're trying to turn this into.
I'm not trying to turn it into anything. I'm just trying to state the
Please.
laws, and I'm not trying to argue with y'all about anything. You get what I'm saying? I'm not trying to argue with y'all. I'm just trying to get y'all to state and prove y'all facts, and y'all have not proven any facts, but for some reason are hindering me in this proceeding. And that's why I took this case to the U.S. District Court in Eastern. That's why there's an open case right now with all of you all, because this is just not, and I told the Attorney General, and I told the IRS, and I did everything else, because at the end of the day,
Please move
all of
on.
this is not right.
I'm telling you
And
now
attorney
that I'm going to
grievances.
be filing criminal proceedings.
Feels something deeper than legal misunderstanding. Miss Battle genuinely believes she's being denied justice, and that alone shapes her reactions. She feels unheard. She feels dismissed. And because she has built her argument on incorrect assumptions, every correction feels like bias, every objection feels personal, but watch how the judge handles it, firm, consistent, and grounded. She keeps redirecting to the actual point of the hearing, the rent. How much is owed? What is the legal basis for staying in the unit? What is the factual record? Despite Miss Battle's frustrations, the judge offers her time, explanation, and clarity, something many judges would have cut short hours ago. The challenge? Miss Battle doesn't recognize that the judge is actually protecting her procedural rights by
Nobody has any facts. Y'all talked about constructive possession. Nobody wants to talk about that. Y'all keep saying that I rescinded a contract unilaterally. That's not the case. It's called notice. And when a notice goes unrebutted, just like if I was to come here, if I was to get that notice of dispossession and get a notice of a hearing, and I missed that hearing because I did not rebut, that would constitute as
cross-examination.
Battle, if
That
you're
would
not going
constitute
to
as
ask
the same
appropriate
type of
questions, then I'm
fault.
just going to silence you. So you get the opportunity to ask your questions, or you can just be silenced.
I don't
Well,
have a real opportunity.
another intense, unpredictable courtroom showdown. Judge Washington stayed firm, the attorney remained focused, and Miss Battle brought every argument except the one that mattered, the actual rent owed. Throughout the hearing, we witnessed the difference between legal terminology and legal understanding, between perceived rights and actual statutes, and between courtroom logic and improvisational reasoning. At the end of the day, the judge's ruling reflects the law, not personal feelings, not creative interpretations, and not misunderstood federal codes. Cases like this remind us why judges need patience, attorneys need clarity, and litigants need preparation. If you found this case as shocking and entertaining as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Trust me, there are plenty more wild hearings on